so they create a solid sealed joint. You can see it right
So welcome one and all to Love Thy Neighbor. Your presence today demonstrates that we're preaching to the choir here. My name is Jack Lepper. My partner Adam Finkelstein and Denise Campbell of our offices will be talking to you a little bit this afternoon regarding a couple of issues that are apparently meaningful to co-ops and condos relating to pet policy to a certain degree and comfort pets, service animals, as well as issues relating to odors, particularly smoke penetration within apartments, from apartment to apartment. We're a big group and we have some outside noise, so we're going to ask for your help. And we're going to talk a little bit about what we outlined for you and some policy concerns, and then we'll take some questions, and we hope it'll be helpful to you and helpful to us as a co-op condo community. Just out of curiosity, by show of hand, who in the room lives in a co-op, not a condo, co-op? Okay, hands down please. And who lives in a condominium? All right. Okay, well I would say it's about a 2/3 to 1/3 co-op to condo group, but that's okay because there is a lot of overlap. We're going to start off with Adam. He's going to talk a little bit about pets, okay, and comfort pets and what's going on in the law and as a matter of practice and policy. Okay, then we'll discuss a little bit about what's going on with smoking and odors penetrating from one apartment to the other. And at the end, we're going to take questions on both topics. So if that's okay, I'm going to turn the floor over to my partner, Adam.
Thank you. Hi, everyone. I said I wasn't going to call on people, but just a show of hands. Of the people who raised their hands before, which is everyone, how many have buildings that have pet policies that prohibit pets? Okay, all the rest are pet friendly. Okay. Before we really get into the details of what I'm going to be talking about, I just want to make it clear that I'm going to be talking about comfort and therapy animals as well as service animals, and I may use the terms interchangeably. There are some differences. Service animals are trained. Typically people know them when they see them. A guide dog, sometimes there are animals that are trained to detect drops in insulin levels for diabetics, detect knocking at the door and alert the owner who may have hearing difficulties. So I'm going to use them interchangeably. There are some nuances, but for the purposes of this afternoon, we'll just treat them the same. Also, I'm going to refer to a certain part of my what I'm going to be talking about as a problem. I don't want it to be misunderstood. I'm not in any way suggesting that comfort, therapy, or service animals are problems. What I'm going to be talking about as a problem is when there's an abuse of the laws and people use the laws to violate the pet rules that are established in buildings. So without further ado, when we're talking about a no pet building or a building that has a restrictive pet policy, what happens when someone comes along and suddenly presents a need for an animal of some sort? There's conflict, there's confusion, and what I find is upset. How could this happen? What do we do? We're a no-pet building, and now we're faced with this. It's very important how you handle it because the laws that are in effect at the federal, state, city, and if you're out in Long Island in the county levels, they protect people with disabilities who are seeking an accommodation to the rules, and you have to be very careful about how you handle it because there are damages and punitive damages and legal fees that could be attributed to you if you violate the law. Comfort and service animals are necessary and appropriate to help people function when they suffer from a disability. What is a disability can be difficult to identify. It's not always apparent from looking at someone, and you may have a neighbor who goes out jogging every day and comes along and says they need an animal of some sort for a condition. You say, well, that person's healthier than I am. What disabilities are not always visible. And that's one of the things that causes the confusion and upset and a feeling that people are cheating. They're not always cheating. In fact, many times it's an appropriate request. when faced with a request for an animal, it's like any accommodation being asked for by a person with a disability. I don't know how many of you have had a request for a ramp or some type of a modification to help someone who has a mobility issue. The laws require accommodations not only physically.
Hello, welcome to the Cooperator Expo New York. Please check out our free advice booth.
That's distracting.
On the third floor. Again, we have
You know,
free
an
advice
accommodation. I'll wait till they
being
stop.
offered by attorneys, insurance, bankers, and other professionals in the room on the third floor.
Okay. Those laws that require ramps and handrails and other type of modifications to a building also require modification to policy. So in those no pet buildings or the buildings that have very restrictive pet policies, you do have to make exceptions when someone presents a viable request, an appropriate request for a modification to the pet policy. The reasonable accommodation, I'm just going to quote from you for you. It's a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to use and enjoy a dwelling, including public and common use areas. What is a disability? And as I said, you can't always see it. And under federal law and state and city law, there's a slight nuance, but basically it's a condition that affects a major life activity. And it could be, that's why that person who's going out running, they may suffer from an emotional disability, depression. It doesn't have to be necessarily something that you can tell from looking at them. And it's critical to determine if the person is suffering from a disability when you get that request, if you're otherwise opposed to making an exception to your pet policy. Because if you don't qualify for a disability, you're not entitled to the accommodation. So what do you do when some... Oh, I'm sorry. Thank you for letting me know. Is that better? Yeah. Okay, my apologies. Should I start over? Okay. So, you know, how do you know that someone who's asking you for an accommodation in your pet policy is entitled to one? You know, HIPAA laws restrict certain information that you're entitled to get. But you can certainly ask for documentation from a doctor or other professional who is treating the person. It doesn't have to be an MD. That they suffer from a condition that affects a life function. So you'll be presented, if someone asks you for an accommodation and they haven't done that, you can say, well, I need to have some proof that you are disabled. And you can get a letter from a doctor, they can get a letter from a doctor that's treating them, saying that this person is under my care and they suffer from a condition. Again, they don't have to get too deeply into the nature of the condition, but the doctor should be able to identify that they are under their care and that they do suffer from a condition that affects a major life function. Part of what you may look at is the doctor should indicate how long they've been treating the person. It's not a critical factor, but you know, if they've been treating them for a day, it's different than a doctor who says, I've been treating this person for several months and this is what they have. So if you get a documentation saying it's been relatively short treatment, you can try and delve a little bit more deeply into it and ask the person seeking the accommodation to have the doctor elaborate a little bit more on the scope of the treatment. Again, bearing in mind that they're not going to go into great depth as to the course of treatment. That's HIPAA protected and you really can't go that far. If it doesn't support the legitimacy, if they can't say that the person suffers from a major life function and this is just a request that may be nice for them because you know, they're good people, you can deny the request. Can you hear me in the back? I know there's a tremendous amount of noise out there. Can you hear me? Louder. Louder, oh boy. Okay. So if they're not satisfying that initial threshold requirement of documenting that they have been under the doctor's care and they suffer from a condition, you can deny the request. and have them, either come back and give you more or just let the denial sit. They may not take it that easy. They may really want and need it, and they'll come back to you. And we'll talk about the interactive process in a few minutes. But once they do satisfy that requirement, then it's a question of what's a reasonable accommodation. And that's what I just said. There's an interactive process that has to take place. There's no specific case law on this, but reading into the nature of what happens when there is one of these requests and an exchange of what's necessary, and it goes towards the other disabilities with ramps and lifts and that sort of thing. I'm of the belief that if you have a situation where someone's asking you for an accommodation, you can discuss with them why a particular breed is necessary. If the building is a no-pet building and a smaller animal would present less of a concern for the neighbors, or maybe a hypoallergenic animal, and the person is saying, well, I want a 90-pound Rottweiler, well, there may very well be a good reason why they need that as part of their treatment. Maybe they suffer from anxiety and they need the larger animal to help curb those feelings. But absent that, I would suggest that you can engage in this process to try and get to a point where if you're going to make an exception to your policy, you're going to allow the animal, you can do it in a way that maybe is less impactful to the neighbors and people that live in the building and have to now share their living space with this animal when they move to a building that was a no-pet building. And again, comfort therapy animals are not considered pets, but the idea is engage in that interactive process. I've recently had some buildings look to be proactive and establish a comfort therapy animal policy. And again, I can't say that if challenged, they're not going to have to make an exception to that policy, but in that regard, they are talking about trying to limit size and breeds to minimize the impact to those people in the building who are not in favor of living amongst animals. I don't know if I have another 5 minutes. I guess unless we could take questions at the end. We'll take questions at the end. I'm going to turn the rest of it over to Jack.
Okay, hi everyone. Just again, hands quickly. How many folks came here?
Testing.
How many folks came here really to hear about the comfort pet issue? And how many people came here about the smoking issue? All right.
Damn it.
Okay. Now, secondly, can everybody hear me? I'm speaking clearly. You can hear me in the back. Okay. We handed out an outline of what we're going to discuss today. Has everyone received that outline? All right. If you haven't received that outline, do not worry. I'll cover it, but it'll be available for you when you leave. Okay, so not to worry. Okay, so a few things. Whether you're a co-op or a condo, I assure you in your corporate documents, if it's a co-op, your proprietary lease and your house rules. If it's a condominium, it's your bylaws and your rules and regulations. You're going to have provisions that say you as a neighbor cannot do things that unreasonably disturb your neighbor. The particular provisions, or the typical provisions, are covered in the materials we gave you. But without representing you, I suggest to all of you who are board, how many people here are board members? Almost everybody. You're going to find it. All right, it's going to be in your documents somewhere. And I'll also tell you that the courts have bounced around a little bit over the last several years on the issue. For the most part, not wanting to get involved. But that changed. That changed dramatically. It changed strongly. And you cannot ignore the issue as board members, because your co-ops and your condominiums are now potentially liable, okay, for all kinds of things. If you're a co-op, you know as a board member that you're a landlord, okay, under a proprietary lease, and that your shareholders are also proprietary lessees. So you are a landlord, and everyone who resides there under proprietary lease is a tenant. That gives that tenant the right to something called the warranty of habitability. All right, a warranty of habitability, which says in the statute, okay, you can't, as a landlord, provide an unhealthy, unlivable condition. All right? It also provides that you can be evicted if your neighbor's activity or the building activity is causing you the inability to really use your apartment. Well, about a year ago, in a decision called Connaught, the court made it very, very clear that secondhand smoke that penetrates into a neighboring apartment will give someone a cause of action and make a landlord liable under the warranty of habitability, under nuisance, and under constructive eviction, to the point of giving someone almost a full abatement of anything that was due of rents over a period of time, even though someone may only be using the apartment part-time. And in addition, legal fees and costs. Now, while that has not applied yet to condominiums, I can tell you that the legislature, the New York State legislature, is heading specifically in that direction, okay, and putting a time frame at which point both condominiums and co-ops are going to have policies to address the odor and smoking issue. Without getting into details about my feelings about marijuana use, okay, that's an issue as well. All right, it doesn't just have to be cigarette smoke. Any odor. So as board members, you have to relatively soon address this issue with your managing agent and with your general counsel and say, what policy should we put into effect and what things should we be doing in order to protect our co-op, our shareholders and residents or condominium unit owners, and candidly, ourselves, from being responsible or liable to people, okay, and make sure that we meet our fiduciary obligations. Again, well, I didn't say it yet, the case is currently under appeal in the First Department, which is the New York City area, all right, but likely is going to make law, and if the state legislature passes laws that require this, regardless, smoking will be an issue. Now, without getting into my outline, I will tell you that the folks in our office, and Denise was very instrumental for both of us in helping us outline materials, so I want to acknowledge that, but also other folks that work, some of our associates, worked on these materials. We asked them, and they're smart, hungry, aggressive people from terrific schools. I said, guys, now that you've done this work, what do you think? What do you conclude? And they say, Jack, they're all going to be stopping smoking in their buildings, aren't they? And guys, if you're asking me my opinion, that's where this is going. All right? Son of a smoker. Okay? I don't smoke, but my mom smoked. Couldn't get her to stop until she had to stop. But that's where this is likely going. Okay? And to ignore it, okay, is probably irresponsible. So I'm talking to you now as a former board member and as a guy who's now been doing this for about 25 years. Forget the law. Common sense says that if the government is pushing regulations to address this and the courts are punishing people who allow it, take serious note of it. A few other things which I can now speak to from practical experience, not necessarily being a lawyer, but this is the world in which we live. No matter how hard you try, and you will try hard, to suggest things to your residents, to caulk all the cracks, to put in air filters, okay? To deal with all that, you're still gonna likely have complaints, all right? For a variety of reasons. Number one, many of our buildings in the city, when I say the city, I include all 5 boroughs, okay? They're not brand new, all right? And they were not intended to stop the penetration of odors and smoke, okay, with the circumstances that were, you watch television from the 50s and 60s, everyone's smoking on television. No one thought about it then. You know, you just watch it all the time. The doctors are smoking on television shows. All right, so no one thought about this. Secondly, a lot of our buildings have undergone alterations. The apartments have been modified. And in making these modifications, not significant attention was paid to the barriers that are between apartments or the engineering of a building. By way of example, without getting complicated, there's this thing called air pressure, negative air pressure, which essentially keeps flow of air in and out of a building appropriate. But what happens when you start messing with apartment buildings is you change the engineering and the air just flows and it moves from place to place. So no matter how hard we try, in earnest, Okay, as board members, as management, as smokers in our apartments, it is extremely difficult to stop smoke, whether it be cigarette smoke, whether it be marijuana, any smoke, whether it be cooking odors, from penetrating from apartment to apartment. It is extremely difficult. If you can do it, that's wonderful. Okay, it's a problem in newly constructed buildings. As good as the engineers may be, or the architects may be, I am telling you from experience, okay? And we listen to all the geniuses tell us how they're gonna fix it. But years later, we're making fees and everyone's still upset, all right? So if you're gonna tell me as a practical problem, what do we do to solve this? The answer is if the smoke's not there, it's not gonna be a problem. Okay, that's a practical answer. And I think that's where the law is going anyway. Now, someone has suggested, well, can't we at least grandfather the policy so as not to prejudice or hurt people who have been residing in our buildings for years? And some buildings have implemented that type of policy. Okay? Whether that will withstand a court challenge, I leave to the future. But as a practical response to all of you, okay, it has proven to be helpful to many co-ops and condos because it minimizes the number of people smoking and it stops it going forward. Secondly, particularly for co-ops, not necessarily condominiums, you have the ability to ask that question when people are interviewing to become a member of your cooperative. All right, I always tell people when you're in a co-op or a condo, you're joining a club and you're subjecting yourself to club rules. So, if you are a board member and this is concerning to you, you can at least ask and have people sign off that they are not smokers and they will adhere to that policy. Okay, so you can do that. You can also modify your corporate documents. If it's your co-op, it's going to likely be your proprietary lease and your house rules, condominium, perhaps your bylaws and your rules and regulations. Okay, you can institute a fine policy. The problem, guys, is proving it. How do you prove someone's smoking in an apartment? Not easy to do. Someone has suggested that we put cameras in everyone's apartment. Who here wants to have a camera in their apartment? Not going to happen. All right, it's creative, but it's not going to happen. So the problem is that the problem is going to exist. And again, I'm sensitive to everyone having their right to do what they want to do in their own home. I'm not trying to be invasive. Okay, but you are going to have a problem where no matter what you do, you are going to have upset. The large majority of folks today are non-smokers for the obvious health reasons. And you as a community will likely be able to push your co-ops and condos in that direction. And I am suggesting, notwithstanding what the appellate division may say, that's probably a wise thing to do, although it will be upsetting and not popular with some of your residents, perhaps some of the people in this room. Now, one of the suggestions has always been when we have windows, we can blow the smoke out our window, or we have terraces. You can smoke, but you can only smoke on the terrace. Two things, okay? Sometimes that works, but sometimes it doesn't, all right? And I have to leave that to your judgment and guidance as to whether it's being effective in your building. All right, unfortunately, depending on where you live and how the wind blows, the smoke sometimes comes back. Okay, and I'll tell you something else, and it's also true of noise complaints. Once your neighbor is sensitive to a problem, they become super sensitive to that problem. So even if conditions improve, they recognize the problem. So you all have an impossible job as board members. You know, it's easy for us. We get to hedge, you know, and charge. Okay, this is your home. This is your home. I remember I actually had a discussion with our president's brother way back when. I think I still had hair. And he said to me, Jack, we're responsible. We have identical interests to the clients on the board, you know, the shelves in the building who were purchased their apartments for occupancy. And I said, Robert, Donald has a brother named Robert. I said, Robert, you're not identical. This is your business investment. These folks live here. It's their home. Okay, and that's what you have to realize. You have almost a responsibility when you join that board even if it's not a fiduciary obligation, okay, I'll suggest it's a moral. You are being elected by people, okay, in a community to represent them as a community. And to allow anyone to be subjected to physical harm or to be uncomfortable in their home, okay, is a real challenge. So, if you have the ability, whether it be through air filters, caulking, or any other devices that someone could purchase to resolve the issue, that's great. Good try, okay? If you want to allow folks to use their terraces or blow smoke out a window and no one is complaining, live and let live, okay, that's for you as board members to resolve. But if you're asking where the law appears to be going, the law appears to be going in two ways. Number one, to require policies to address the issue. Number two, in public housing, to ban it altogether. Absolutely no smoking in common areas. And the courts, not in the condo yet, but in the co-op, subject to appeal, the courts are saying, if you allow this, okay, we are going to take action against the landlord. All right, and I think it's a heartbeat away in the condominium setting as well. So that's that. If you look at the material we provided, okay, we provide what is probably, if you're a co-op or a condo, something very similar to your corporate documentation. We refer to one or two of the relevant cases that are recent. Guys, we're in the world of technology. Just Google it. You will have more information at your fingertip in 3 minutes than I can talk about. All right, but it's going to, I think, essentially say what I've covered today. I'm just going to walk through real quickly some other things. We gave you some modified language for policies. I suggest to you your general counsel and your managing agent may have a variety of different policies that you can review and consider and work with you in enacting something that will address the issue. What you cannot do, everyone, is sweep it under the rug. Okay, I suggest being proactive here, initiating a policy, okay, and then enforcing that policy. To initiate a policy, but to ignore it is not going to help you. In fact, it may be more harmful to you than helpful, because now you've neglected enforcing your policy and you've breached your contract. Right? The proprietary release is a contract between the corporation, okay, and its shareholders and its proprietary lessees, and with a condominium, the bylaws, okay, and the declaration can be deemed a contract. Okay, so be very careful about that. I think the information we gave you will be helpful. It's a good guide. It's going to help you raise the... We are not going to solve the problem in the 20 minutes we have here to discuss it, or 15 minutes of questions. But I think what we've done is given you a fairly good handle on where this is all going and what the issues are, and enough information in our outline, thank you, Denise, in our outline that you can now have a basis for moving forward and dealing with these issues. Again, it's not that we're looking to interfere with anyone's personal life, but we have to be realists, okay? And we have to also be understanding. And I say to folks all the time, you move into a co-op or a condo, you are joining a club with a lot of other folks, okay? And you're subjecting yourself to community rule. And the courts have said it. The main case was Lewandowski, okay? Business judgment rule. If it's for in furtherance of the legitimate interests of the corporation, courts aren't getting in the way of this. So you are empowered. You are empowered to enact these policies. And secondly, and the courts have said this, you also as residents are empowered to leave and buy a private home in the middle of the country if you don't want to be living so closely to other people. All right, so thank you very much for your attention. We are going to take questions. All right, and though we're talking about the service dog issue and the smoking issue, it really also, what I'm talking about, relates to nuisance type issues. And so we'll try to answer those questions as well. We're going to take them one at a time. It might be difficult for people to get up. I'm going to work my way around the room this way, okay, and then we'll go back. So we'll start here. We're going to work our way around. Yes, ma'am.
Microphone.
Here's the mic. Oh, you want the mic? Can you pass the microphone around, guys? Just take it right out of the, yeah. That might be easier. It's too crowded.
It was my understanding that this session was about noise issues, and I wonder if you could take a moment to
Absolutely.
address noise issues in the same fashion that
Yep.
you've addressed these issues.
Sure. I mean, a lot of what Jack presented for smoking is for noise too. There's a provision in a proprietary lease that talks about objectionable noise and odors. So you can certainly look to enforce that provision specifically if there's a noise complaint. Most of the time, the problem gets solved with a carpet rule, and I'm assuming everyone here has some type of a carpet rule, in effect requiring at least 80% of the floor area to be covered. Many times that you find out is the source of the problem. People are not in compliance with that. So the first step you'd want to do there is to have an inspection take place to determine whether the floors are properly covered. If they aren't, you definitely would want to enforce your house rule to require that to be done, and then you would see if that solves the problem. You'd re-inspect, and that many times does. If it doesn't, it's not dispositive. And I've had calls where the people say, well, I have carpeting, and what more do you want? Well, that's great, but the fact that you have your 3 kids who are playing hockey in their room all hours of the night, that doesn't cover it. So, you would be able to continue to enforce your governing documents to address that. In a co-op, it's you have 2 options. You could bring an eviction action, or you could bring an action for an injunction to stop the conduct. If it's in a condo, you're really limited because you don't have the landlord-tenant relationship. You would bring an action for an injunction as well. And you would basically say that, it's against our rules, and if you violate the rules, you can go to the courts and get relief from the courts for contempt. The difficulty, like Jack mentioned with smoking, is enforcing the rules, catching the people. If you have a staffed building, it's a little bit easier. You call down to the doorman sends the porter up, the porter makes note of the noise, they go to the neighbor, tell the neighbor, we have a complaint, please turn it down. The porter then fills out a report, and then you have that with the business records of your building. If you don't have that type of staffing, it becomes a little bit more difficult because the courts, eventually you're going to be going before a judge and you're going to need to present evidence. And look, there's a lot of Hatfield-McCoy situations that go on, and the judges are aware of that. And you're asking for some pretty strong remedies, throwing someone out on the street or having a potential jailing offense for violating the order. So what you're going to need to do if you don't have that type of staffing is figure out a way how your building can collect evidence of the problem. The person who's receiving numerous, let's say it's an ongoing problem between one neighbor and the next. It's music playing, at 1 o'clock in the morning when the person gets up for work. You have that person obviously notify your managing agent, make a log of the complaints. I've had people with their phones make a recording showing the time that it's going on. And you need to collect your evidence. But if you do have the evidence and it is a process to collect it, you could then go to court and enforce those rules.
So just as an add-on to what Adam is saying, 1, the judges consider noise disputes to be worse than matrimonials. They can't stand them. They don't know what to do. They get angry at everybody, and they punish all sides. They just don't want to hear it, pun intended. Okay? So that's problem number 1. It is, while there are rules in place, it is incredibly complicated and difficult. All right? 2, there are firms, acoustical engineering firms, that specialize in reading the noise coming from an apartment. And there are code requirements as to how much noise relevant to ambient noise you're entitled to have. Ambient noise is the typical noise you would hear, not in a room like this, but in the ordinary course given certain times. And so you can test to see whether someone is doing something that exceeds the ambient noise. What often happens is that when somebody moves from an apartment and the couple that was there either works full-time or perhaps they were seniors, and then the next family moves in, and Adam says it's a young couple with 4 kids who love wrestling. And so the change of person within the home now creates a different situation, and the person below who's been living there for 30 years peacefully, doesn't know what to do with themselves. Okay, so all you can do as board members, number one, stay neutral. Don't get angry. Don't involve yourself. Okay, because you live there, they will be calling you at 3, 4 in the morning. I know you want to be nice and helpful. All right, I know it costs money to use your attorneys or to have management do things, but I'm suggesting to you, If you involve yourselves, it's going to be rough on you. Okay, what you can do is make sure the rules are enforced, floors are properly covered, people are not playing their stereo or their TV beyond the hours they're permitted, okay, and that they're behaving reasonably, and that you have management and maybe staff try to make a determination as to what can be done to cause everyone to live comfortably with one another. If you are unsuccessful, you may have to take it to another level, okay, and create objective proof, which is going to make probably one side happier than the other. But I'll tell you this, it's not unusual when both sides think that there's a process put in place that's being handled objectively and fairly, that both sides settle down and learn to tolerate. Sometimes time heals, all right? So it's a very difficult problem. I'm not suggesting that any of us have a magical answer. If someone tells you they have a magical answer, check with somebody else, okay? Because it's just not there. But that's it in a summary.
Well, just one thing to add on that, I actually have seen where you mediate. You know, sometimes you get the people to sit down, and the people above don't realize. You know, they may not fully appreciate, because some people are just not used to having people living 6 inches between a wall or a floor. So Jack was just saying that there's free mediation through the courts. The City Bar Association, they used to have a program where they offered mediation. So it's certainly something that you could speak to your property manager and your attorney if you get to the point where, you know, you think that there could be a breakthrough. Sometimes people just dig in and you're not going to be able to deal with it that way, but it's certainly worth a try. Next. Well, it can be the building if there's a violation of the lease or the governing documents. It could also be the person who is being hurt by the conduct under a theory of nuisance.
Okay, yes ma'am. Oh, can you pass the mic? I was actually working this side of the room first. So I'll come to you next. In the back, yes. Denise will do it? Okay. Thanks, Denise.
How about cooking smell? Like someone, they deep fry the fish and they open the door, so the whole hallway is full of that kind of odor.
That's the objectionable odor that I was discussing, and it's the same type thing. You know, you're not supposed to do it. You're living in a tight community. It's dense population in your building. You're not supposed to be doing it. I mean, there's always the cooking cabbage example, but frying fish is the same thing. That's typically a violation of the governing documents, and you can take the same action I just described against that.
Take this one, then we'll come here, Denise, okay? Go ahead.
If your building is dog-friendly, has no weight, breed restrictions, you have certain rules like the dogs must be in the service elevator and dogs are not allowed in the laundry room.
Right.
Do you have to make an exception for comfort dogs?
Yes. Yes.
As opposed to service?
You do. You do, because really the law doesn't distinguish between the service and the comfort animal.
I'm not sure if you're quite...
The question was, if you have a pet rule in the building, you have a pet-friendly building, yet you have restrictions that you have to use the service entrance. If someone has a service or a comfort animal, are they subject to the restrictions? Basically, you know, I've had a case, it's not necessarily on point, but the child had a disability and they were allowed to have a dog. The parents, when they walked it, were required to use the service entrance. They sued. They didn't think it was appropriate. The child was never denied access through the main entrance. The parents lost because the rule, they weren't disabled. Remember, I said one of the first things is determining whether they're entitled to the special privilege. But basically, unless the imposition is something that is not a huge difference. You know, if you're going to make someone walk up and down the stairs with a comfort animal, because people who have pets, that's not going to be something acceptable. If let's say the service entrance is 5 feet away from the main entrance, you may be able to get away with it, but I would say be careful. Those animals are extensions of the people. They're not pets. They are an extension of the person in need, just like a seeing eye dog. I don't think anyone would suggest that someone with a seeing eye dog has to take the stairs. Comfort and therapy animals under the state and city laws are the same.
Denise, up here.
So I want, Adam, the question that you answered with respect to noise, I want to ask it of Jack with respect to smoking, which is the evidentiary question, because it's a little different with smell than it is with sound. And I think we have a situation on a condo building where there's been, let's just call it the super sensitive type of tenants that surround a woman who does smoke. And we've sent staff up a few times. By the way, I'm actually interested in your views of whether we can ask staff, union staff, to do this. That's part of their job. But assume for a moment we can. We've had some instances where they've said, yep, I smell smoke. We've had some instances where the complaint has come in and they've said, no, we do not. And so we therefore have an evidentiary mix. I'd say if we were to go to court, is there some objective thing that we would need? And first of all, and what is the record of courts intervening and granting some real remedies in a condo, finding a nuisance? We have a typical bylaw of the sort.
So, did everyone hear the question? Okay. So essentially the question is, if you're in a condominium situation, okay, how do you create a case to prove that somebody is smoking and that smoking is causing a nuisance that's worthy of action? Okay? Now, the courts have addressed that issue at a lower level. In fact, there was a civil court that said, in New York City, that said, we don't believe the plaintiff, the occupant of the apartment, brought sufficient evidence to prove that they were harmed in any meaningful way as to constitute a nuisance. Okay? However, so two things. All right, two things. Number one, it's like any other court case. Each side brings their proof. So if your building staff takes notice and testifies, okay, that is proof. They can't take air samples, although it's crazy and the costs get ridiculous. So you take air samples as well, all right, and that would all be proof to show that there was the burden, and it'd be the courts balancing the proofs provided and coming up with a determination. That said, and notwithstanding the lower court's decision, which said we are not going to intervene, I am telling you, I think the law is going in that direction anyway. And so in a condominium setting, all right, that's why I suggested it might make sense to proactively address it by rule or regulation. And if need be, because you don't want to create too much upset, for instance, we have a building that's a couple hundred units, and there's probably 3 or 4 people who smoke in the building. And I think the board's inclination there will be to grandfather for those 3 or 4 units, knowing that the problem will go away, okay, and not create a fight within the building. So it's a matter of utilizing experts and staff and management and neighbors in making a case and seeing what the court does with that evidence. It's not easy. You want to, Denise, work your way around?
Hi. We're in a co-op building and we haven't adopted...
A little louder.
We're in a co-op and we haven't adopted a smoking policy yet. But in the meantime, you suggest that we can ask during the interview for an applicant if they do smoke, and if we ask them that and they ask why, what is our legal backing and what will we say?
All right, well, number one, I don't think, and I don't want to give guidance here as to how you should conduct your interviews, but number one, I think you have the right to ask the question. I don't think you have to answer the as to why. They're not interviewing you, you're interviewing them, okay? And if they can't figure out from the question what the concern is, that's on them. That said, I think you'd be much better served if a rule was in place and then you went forward asking that question. All right, Bob Kagan, my boss, who's no longer, who's moved past a number of years ago, said, Jack, if you treat everyone the same, you're going to keep yourself out of trouble. And if you can't say it out loud, don't do it. Okay? So my suggestion for most people is enact rules that are going to be applied uniformly. If you want to grandfather for the handful, you can probably get away with and be successful in denying people if they're smokers. Just like if they, like to make loud noise by way of what they do. So you probably can justify it, but you'd probably be on even better footing if a rule was in place.
The other thing to bear in mind is some people don't necessarily recognize themselves as a smoker. The person who may go out and once in a while take a puff may answer that question legitimately thinking they're not lying to you. And then really what happens if they do lie to you, you really can't undo the approval. But it certainly is something to put it at least on their radar that this is where the building may be going.
And maybe adapt your application process to provide for it. Okay? It's a fair question to ask.
Hi, I'm Andy Wilczek, and I represent apartment owners against boards. Compliment you on the thoroughness and clarity of your presentation today. I have a dream that on noise complaints that there would be a rule that the complaining parties have to go to mediation, that the board requires them to do so, and to share the cost. Because I think that would save the trouble of guys like me and you having to charge our clients attorney's fees, or in my case, ask the board to pay me.
Sure.
Agreed.
Agreed. Want to take that side a little bit?
Let's work your way around.
Can you hear me?
Yes.
I have a problem with my upstairs neighbor on the 6th floor. I'm on the 5th floor.
He's a big guy. He'll take care of it. Don't worry about it.
Oh, I wish I could do it. So it's the last 3 years that she has, very bizarre, have given me odors such as turpentine, gas, benzene, cigarette smoke. I've approached the board. I've been in touch with the senator and councilman, the borough president of Brooklyn, anybody and everybody you can think of, and nobody is trying to help me. Nobody has helped me.
The politicians, a lot of times people will say, "Oh, contact the politician," and you know sometimes they do latch on, but something like that, they're probably not going to get much progress. It's really, what is your management company? What has your board said and done?
Well, the board is very, how can I put it?
Ma'am, I'll make it very easy for you.
What?
Here's your answer. You've got to find somebody who's willing to represent you and take it to the board and to management, okay, and let a court decide whether you're entitled to something, any kind of relief, or because you've done what you've done, the board and or management react to someone helping you. They're clearly ignoring you.
Absolutely.
I can't speak to your personal circumstances as to whether you're right or wrong, because I don't know. But based on what you're saying, I suspect there won't be a change of behavior.
I have I can't even live in my apartment.
I hear you.
I have to leave to sleep.
And what I can tell you is, you're in a co-op?
Yes,
If you are right,
I am right.
if you are right, then a court will award you fees and costs. So you have to speak to somebody. I'll tell you candidly, we're on the landlord side. We represent, the co-op and condo boards. And we very, very, very rarely will take on a case on the other side. But there are people who do. They're smart, they're competent and able, and you got to find that person to help you solve this.
If you contact the City Bar Association and ask for the chairman of the Landlord Tenant Committee, talk to them. If they can't help you, they'll recommend someone on their committee who's active, involved with promoting landlord tenant law, and they'll be able to talk to you.
Thank you.
Do you have any information on odor issues with medical marijuana?
Well, in New York State, marijuana is not legal in smokable form. So someone who's claiming that they're entitled to smoke in their apartment marijuana, that's not legal under New York law. There are edible and other forms that are appropriate, and it's for a very limited type of diseases, very serious, deadly diseases. If you're out in California where Snoop Dogg gets one for headaches, that's something different. There it's legal to smoke. So right now, smoking marijuana is not legal, and it's not part of any accommodation they can request. Not in our state. Take it out of state, it's a whole other story.
I also don't know that would give justification for creating a nuisance. So we'll see how that plays out. But I suspect that it'll be treated in a like manner with the odor issue related to other smoke.
Right. And also the secondary question to that, in a co-op that has the presence of rent-stabilized tenants who are still under the
Sure.
sponsor's control, and you can't get the sponsor to deal with a nuisance, is there any case law or anything that exists for a co-op board to be able to do? Because if we're responsible,
I don't believe that there's been any determination that smoking is a right that a rent stabilized or rent controlled tenant has. In saying that, I haven't done deep research into it, but I would suspect that it's not an amenity that would be a diminution of service if you took that away. And I believe that you can enforce no smoking rules for a rent stabilized and rent controlled tenant.
Same thing with noise,
I would
right?
take it a step further in saying the law of the land right now is the Connaught decision. All right, until changed, that's the law of the land. And whether the person who's smoking and creating the nuisance is a proprietary lessee or a stabilized tenant, okay, the corporation as landlord cannot allow that to happen because there's exposure there. So in your situation, the board would have to take action against the sponsor, who's a shareholder like everybody else, and force their hand.
Why don't we try the other side?
Yep, these will flip. All right.
We have a conflict resolution committee. A conflict resolution committee. So when we have two neighbors, usually upstairs, downstairs neighbors, who are complaining about noise, we try and get them together and sort it out. Hopefully they can find a compromise and things are better. We'll do it 2 or 3 times max, but then we sort of leave it to them beyond that point. So if, say, one of them, kids upstairs, you need to put the carpet down, kids need to be down at a certain time, these are quiet hours, we supervise to see that those things are happening. And if they are happening, but the downstairs neighbor is still complaining of noise, and there's no other evidence, I guess, other than their complaint. So far, our policy is then the two of you need to, in some way, like the downstairs neighbor, take it to court. Is that okay for us as a board to, or are
You're
we
in a co-op or a condo?
We're co-op.
The answer is, it depends.
It depends.
Now, it's a cheap way for me to get out of the question.
Right.
When I say it depends, if the level of noise would be sufficient to raise an issue of breach of warranty of habitability,
Right.
then if the noise being made by a neighbor is sufficient as a matter of law to cause a breach of the warranty of habitability, regardless of the fact that the co-op board has put an alternative dispute policy in place, the co-op as landlord remains landlord. Okay, so if on the other hand the noise level is not sufficient to warrant a legitimate claim for a breach, then I think what you've done is satisfactory. So I know that's a cop-out, but that's kind of how I would, advise on that issue. In a condominium, condominium is a little bit more difficult. Same concepts, but I will tell you the courts have been a little more lenient on the boards of condominiums on these types of nuisance issues. Essentially saying the board can only do what it can do. Court has said that it didn't find against the board for not enforcing its rules when someone brought a like-type complaint. Of course, that case could go another direction with another judge or another court. So I think in a condo, you're probably a little safer under that circumstance, unless it was probably a blatant breach. These are all problems. I mean, there's no easy answer to this.
I'm a member of, with no personal attacks here, but a hostile board in a borough, and they are all smokers, and I am on that board as new blood, and have been elected, and I remind them that they were elected as well, and I'm asking for some guidance as to how a board member deals with other board members that have entrenched themselves in with the power that the board has to isolate. I've brought up probably 6 or 7 items, and they're always tabled. And unfortunately, I missed a board meeting last night, and the no smoking got denied based on the fact that I was not able to attend. So I'm asking you, what do I do, or do I have to just sit there and eat it against a board who just doesn't want to change?
Okay.
Well, first, everyone comes to the boardroom with their own thoughts and beliefs. So I can understand where a board that they're all smokers, they're not going to necessarily be that thrilled to start talking about policies that are going to directly affect them. But I would think that you can go to them and now present to them some of the information you've received today, and advise them that, look, we're facing some exposure here if we don't deal with this seriously. I don't know if you have your attorney present at meetings, but it may make sense to maybe get in touch with your building's attorney and ask them to weigh in a little bit and give some guidance. And hopefully they'll see that the legal ramifications of not taking these actions outweigh their personal bias, and create an impetus for them to take some steps in the direction that's going to steer the organization out of trouble.
You're all, as board members, fiduciaries, which means you have a duty of care and a duty of loyalty. The duty of loyalty means basically you're acting in good faith for the interest
Hello, our last expo of the day, seminar of the day is sharing staff more for your money.
This will be our last question.
Again, our last expo of
Formally,
the day.
we'll stay up here a little bit longer and take individual.
More for your money in seminar room 1.
So the duty of loyalty means you got to be acting in the best interest of the corporation, no personal gain. Duty of care, okay, means you have to act like a reasonable person and do what you believe is reasonably best for the corporation. What I would suggest you do is outline the issues, including the cases presented. I would copy your corporate counsel. Say these issues raise real concern to me, and I want to make sure we're acting responsibly. As a board member, I owe this to my corporation and my community. Okay, and I want this addressed with the advice of counsel at our next meeting, and then see what happens. Everybody, thank you very, very much for the attendance and for your help.